Foundations of refugee protection. Legal frameworks and institutional roles. Refugee protection is not simply a matter of humanitarian goodwill. It is underpinned by an extensive and evolving legal and institutional framework. This system provides the foundation for defining who qualifies as a refugee, what rights they are entitled to, and what obligations states have toward them. The core of international refugee law is found in the 1951 Geneva Convention, relating to the status of refugees, and its 1967 Protocol, which together lay out the criteria for refugee status and key principles such as non-refoulement. These international treaties are supported by a web of international human rights instruments, regional frameworks, and national legal systems, all designed to offer legal recognition, protection, and pathways to safety for displaced people. This section unpacks these legal foundations and explains the operational role of the United Nations High Commissioner for Refugees, UNHCR, which is tasked with upholding refugee rights and coordinating international protection. Through practical examples, legal precedents, and global case studies, learners will explore the mechanisms through which international protection is delivered and tested in the real world. The definition of a refugee, as laid out in Article 1, subsection A(2) of the 1951 Geneva Convention, is both legal and protective. It describes a refugee as a person who, owing to well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group or political opinion, is outside the country of his nationality and is unable or, owing to such fear, is unwilling to avail himself of the protection of that country. To qualify for refugee status under this definition, an individual must meet 4 cumulative criteria. First, they must be outside their country of origin. Secondly, they must have a well-founded fear of persecution. Thirdly, the persecution must be linked to one or more of 5 protected grounds: race, religion, nationality, political opinion, or membership in a particular social group. The fourth one is, they must be unable or unwilling to seek protection from their home country. This definition is widely recognized and applied by over 149 countries that are parties to the Geneva Convention and/or the 1967 Protocol. It forms the basis for legal decisions in refugee status determination worldwide. Initially, the 1951 Convention was limited in scope. It only applied to events occurring before January 1, 1951, and was mainly focused on post-World War II Europe. The 1967 Protocol removed both the temporal and geographic limitations, giving the Convention universal applicability. Today, this framework underpins refugee recognition and protection in all parts of the world, regardless of the date or origin of displacement. Non-refoulement is one of the most critical elements in refugee protection. Article 33(1) of the Convention states, "No contracting state shall expel or return a refugee in any manner whatsoever to the frontiers of territories where his life or freedom would be threatened." This principle is binding on all states, including those that are not parties to the Geneva Convention, as it has become customary international law. Non-derogable, meaning it cannot be suspended even during national emergencies. Applicable to both recognized refugees and asylum seekers until a decision is made. There is a limited exception, Article 33(2), for individuals who are considered a danger to the host community or have committed serious crimes. However, this is interpreted narrowly and does not apply if the individual would face torture or death upon return.